The people of the state of New York versus Jude Francis.
Good afternoon, Your Honors. I'm Janine Yunus from Appellate Advocates, and I represent the appellate, Jude Francis. I'd like to reserve 2 minutes for rebuttal.
2 minutes?
Yes, thank you.
You may. Counsel, does this case come down to a straightforward statutory interpretation analysis?
I think that's where it starts, yes. It's a question of whether or not the board exceeded its authority when it interpreted offenses in the correction law to include youthful offender adjudications. I think
And
that's
what's our standard of review of that?
Your standard of review is whether or not the board abused its discretion in interpreting the statute in that manner, which we're arguing that the board did. It conflicts with the statutory scheme underpinning youthful offender legislation, which precludes.
But if 720.352, CPL 720.352, not only recognizes that there can be a statutory or a court authorization for access to YO records, but also says that docs, and the board consists of docs employees, that docs employees have access to these records to the extent that they find necessary to comply with their duties and obligations. Why don't they have this access, and why can't they? And the access has to mean for some purpose, the purpose here being to satisfy the requirements of their SORA duty.
I don't think that access is commensurate with assessing points in those categories. Our argument is that the automatic assessment of points and risk under risk factors 9 and 10 conflicts with the youthful offender.
Let me try it differently. You can see that under 720.352, the board has access to these records, that for the board, these records are not treated as confidential.
Just because they're not confidential.
No, that's a yes or no.
So, well, they're confidential. I suppose that the board does have access to them. The board probably should know about youthful offender adjudications.
What would be the point of that, if not to use those records for some purpose, that purpose defined by the SORA statute?
Well, our position is that in certain circumstances, youthful offender adjudications could be the basis for an upward departure, certain rare, exceptional circumstances.
Oh,
And
let me ask you about that, because I saw that in your brief, and I'm a little perplexed as to this particular argument of yours, because I thought your argument was that a YO adjudication is not a conviction, and therefore it can never be considered by the board. End of story. But yet you're arguing that there may be circumstances when it can be considered. I don't understand how you square that with your statutory interpretation argument.
it's not a conviction, so it shouldn't be considered under the prior crimes categories for the automatic assessment of points. There is, however, a difference.
What about under the prior criminal history?
Sorry?
Is that different?
It is different. You mean criminal history in the guidelines?
Phrasing in the statute, yeah.
It's
Well-
the board's own category. That particular categorization is the board, it's of the board's making.
Yes, but that, in that way, the board is wrong. The board should not have mandated the automatic assessment of points for youthful offender adjudications, because those are not indicative of irretrievably bad character or risk of recidivism in the same way that adult conduct
Well,
is.
the board said that it was, and the board is made up of experts on this, so why would we not defer to the board in that regard?
Well,
Or
because-
at least give some credence to that.
Because in that way, the board's interpretation of the statute conflicted with the legislative intent underlying the youthful offender legislation, which is
168L doesn't even limit the board in determining the factors to prior criminal history, but the language says such guidelines should be based upon but not limited to the following, and then gives a long list, but it doesn't, presumably, if there was statistical evidence showing that men who are under 5'6" were more likely to be sexual offender recidivists than those over, the statute allows the board to take that into account, no?
the statute allows the board to take offense. that specific part says that it can consider offenses. But offenses isn't defined in the SORA statute, first of all. I disagree with the Attorney General's interpretation, which says that offenses, or understanding that offenses should be defined as it is in the penal law. The penal law definition of offenses is extremely broad.
Doesn't 168A, the definitional section of the SORA statute, equate convictions with offenses?
It doesn't, as far as I know.
Okay.
Well, I mean, the CPL actually says in the YO statute that YO adjudication is not an offense. Doesn't it say that?
Well, it says it's not a conviction, a judgment of conviction.
No, I
or
thought
any-
the rest of the sentence goes on. A youthful reading from 720.35 sub 1. A youthful offender adjudication is not a judgment of conviction for a crime or any other offense.
But it's not a judgment of conviction for any other offense.
Yes.
Doesn't mean it's not any other offense, right?
But, right, that's true. It's not a judgment of conviction, but as to whether offense in the SORA statute should be interpreted to include youthful offender adjudications, that is what we are arguing it is ambiguous and conflicts with the legislative intent underlying the youthful offender legislation.
But all that SORA, all that the board says is not that a YO adjudication is a conviction. They never say that. In fact, that's not their position at all. Their position is that a YO adjudication is a reliable indicator, as would a conviction, but for this purpose, is a reliable indicator of the risk of reoffense. And for that purpose, they're using it. They're not using it in violation of what appears to be the purposes and intent of the CPL. They're not attaching a stigma or attaching some other program to his conduct. They're using it as a reliable indicator of risk of reoffense, which, as you know, we've said before, is not a punishment.
Well, I think that's the point at which we might go beyond statutory interpretation and look at the science, which we cited extensively, which shows that crimes committed by youth are not indicative of recidivism or bad character in the same way that
That's
adults.
just two competing opinions on that. I mean, that doesn't really get us anywhere, does it? Even if we do consider that.
You mean the board's?
You have certain experts saying it's not, and then you have the board's experts saying that it is, so.
As far as I know, all experts, all neuroscience and psychological experts agree that youthful behavior is not indicative of bad character in the way that adult behavior.
But that it's not predictive of future, of recidivism?
Exactly, yes, it's not.
So if a 17-year-old commits even a sexual offense, all right, not the kind of, which is not the facts here, I get that, gets a YO, and 2 years later when he's 19, or maybe 3 years later when he's 20, does another one, nobody should look at the underlying facts of that?
That's exactly.
First one?
That's exactly where we would say an upward departure might be appropriate. Those very rare circumstances where somebody had committed a very similar type of sex crime as a youth and then as an adult, that might show that he hasn't, that actually was more indicative of his character. But typically, youthful behavior is not indicative of one's character as adult behavior, and one should not be penalized. That's the whole purpose of youthful offender legislation, is not to allow somebody to have that counted in any way against them in the future.
It's also to prevent the stigma of having a criminal record, right? And here, this defendant has a criminal record, not because of something that he did as a youth, but something that he did as an adult. So how does that contravene the purposes?
Well, first, there are two things. That first of all, it infringes upon the integrity of the youthful offender adjudications if we're carving out this exception, which the legislature really hasn't. It's the board who's done that. And second of all,
Well, but in all fairness, the board carved out also the JD exception, right? And case law has since said that that's not applicable, but, so,
Yes.
right?
yeah, but I wanted to get back to the other part, which is that one might have a criminal, someone might have a criminal record at that point, having this additional youthful offender adjudication be used against him is it's an increased penalty, and that's what we're arguing should not be permitted.
But doesn't the
that-
CPL already recognize that 720.35? Doesn't it already, as a statutory matter, meaning the legislature intended it, already recognize that YO adjudications can be used for what I read this provision to mean, either for the benefit of the youth, like the educational plan, or for public security, which is like docs and the Article 10 provisions? It already takes that into consideration. How is the board acting in abuse of its discretion or arbitrarily and capriciously by interpreting that it could look at the YO adjudication for purposes of risk assessment?
It can look at it. That's the point of the upward departure. But it can't count as this automatic, in some cases, in this case, it was
What
25
you're saying is it
points.
can't fit into categories 9 or 10, but could it fit into other categories?
Not another category. It's an upward departure, which is a separate,
all
it's a
right.
separate mechanism for,
Did the defendant request a downward departure?
yes, he did at the SORA hearing.
Mm-hmm.
The point is that these can't be considered the same way that adult convictions are. That's why there could be the safety valve for a situation in which someone
I guess what I struggle with it is that a JD isn't a criminal conviction, even though it's a determination based on an act that if committed by an adult would be a conviction, whereas the YO is an actual conviction, and then at sentencing, the court ameliorates the effect of the sentence. So there actually is a criminal conviction, and then at sentencing, that criminal conviction, the effect of it is ameliorated, and someone's given a second chance and say, we're not going to give you a record, we're going to say this conviction is now a youthful we'll give you a YO, and therefore it doesn't count against you. But that isn't the same as saying you can't consider it in a SORA setting. It seems we allow hearsay through Mingo. We allow an enormous amount of information to go before the SORA board it seems to me, without any restrictions on it at all, even where there's not even been an adjudication. Here, there's been an adjudication. In many instances, there's been a verdict of one kind or another, or a plea, and then, on top of it, we go around, we're saying that you're given a break, and what's being considered is you don't get two bites at the YO adjudication. If there's a second crime, then the acts that underlie the adjudication could be considered.
Well, there's nothing in the SORA statute that says that the YO can be retroactively sort of taken away.
You see why I'm asking you about the categories, because I could see the strict statutory argument maybe for category 10, but I don't see it for consideration for the initial determination. I guess that's what I'm struggling with. So in other words, all right, so you're saying it can only apply to upward departure. I'm saying to you is you have all these categories. Many of them include a consideration of acts that you've committed before. In category 10, though, it specifically refers to recency of prior felonies or sex crimes. You're saying that this wouldn't apply because a YO is not a crime.
Right.
Even though the acts underlying it are a crime.
They can still be considered. Again, they can be considered, but they just can't be assessed mandatory points, which in some
So in
cases.
other words, 9 and 10 are out, but the other categories would be in, is your argument.
Yes.
I see, okay.
Yeah.
Just, I got it, I understand it then, okay. Thank you.
Thank you,
Thank you.
Counsel. Counsel?
Good afternoon, Your Honors. Anthea Bruffy for the people. The board and the SORA hearing court appropriately considered the prior youthful offender adjudication of the defendant. And that's based on many provisions in the SORA statute.
But isn't really the core of the CPL YO framework that when this young person is adjudicated a youthful offender, it is the court deciding something so serious as you get another chance, you will not have to suffer the consequences of being convicted for these actions. And doesn't that equate with your slate is clean, you are now on the same footing with someone who had not committed this conduct?
That's absolutely true
Okay, so then why can the
Until-
board look at it?
Well, it's absolutely true until that offender commits another sex crime. So the youthful offender, by the provisions of the youthful offender
You
statutes.
don't mean another sex crime, you mean a sex crime.
A sex
A sex
crime,
crime, yeah.
assuming that the YO conviction was not for sex crime. I stand corrected. So in this case, it wasn't a sex crime. The offender was convicted of a non-sex crime. He received his YO adjudication, and if he'd done nothing further, he would not have been stigmatized.
But when you get adjudicated a YO, the judge doesn't say, unless you go and do something else, and then this is going to count again.
Doesn't, but case law provides that a youthful offender, if he does something else, the court can then consider that YO adjudication in enhancing a future sentence. And that's
Well,
true.
have we said that, or just the appellate divisions?
The Court of Appeals has not said that. However,
Okay, I just want to be clear
in-
about that.
yes, however, in even a more difficult situation, in the juvenile offender situation, where an offender is, it's not juvenile offender, juvenile delinquent, where the delinquent could be 13 or 14 years old, he becomes a juvenile delinquent based on a finding. There's a confidentiality statute in the Family Court Act, 381.2, which provides, like the YO confidentiality rules, that this YO finding is not going to be public, but under subsection 2, it specifically provides, the legislature specifically provides, and so I don't get it wrong, let me read what it says. Notwithstanding the provisions of subdivision 1, another court, in imposing sentence upon an adult after a conviction, may receive and consider the records and information on file with the family court unless the records and information has been sealed under a provision that there's a finding in favor of the juvenile. So if there is a adverse finding, the child is 13 or 14, he's covered as the youthful offender is covered. But then if, as an adult, he commits a crime, then the court, by statute, is allowed to consider that in enhancing a sentence.
So where is the statutory language that allows this? You talked about the JD
There is not
statute.
one, but by implication there is, based on
Where is it implied?
the SORA statute. Well, let's back up. The confidentiality provisions in the CPL have many exceptions. And let me just get to that. Provides that YO records are confidential except where specifically required or permitted by statute. And all the provisions in the SORA statute which allow for the board and the hearing court and DOCS employees to access these records and use them to make a risk level determination, by implication, permits it.
Well, it's
All
not
right,
the
so,
board,
let's,
Sorry.
if they have access, what do you say in response to the argument that was made by your adversary, that access doesn't necessarily mean you get an automatic point assessment under factors 9 and 10? It's two different things. To say you can have access to this and maybe use it for to request an upward departure, as opposed to it's an automatic point assessment under
Well,
9 and 10.
According to SORA 168-L, subdivision 5, the legislature's provided this scheme where the board is required to issue guidelines. And one of the provisions is, in this subdivision 5, it suggests that the board should consider an offender's, the nature, the date, and the number of prior offenses.
All right, so
So
that
that's
brings me
the-
to the question about the plain language.
Yes.
If that's where you're going to hang your hat,
it's one of
why
the
is this
hooks.
an offense, given the language that I asked about previously?
So prior offenses, it does not say prior criminal convictions. It doesn't exempt YO. So the board has the statutory authority to issue guidelines. In the guidelines, which I appended in the respondent's appendix at 11 to 12, the board has specifically said courts may look at YO adjudications in
Yeah,
making.
but that's somewhat circular, to say that the guidelines say it, therefore it's allowed.
Well, the legislature has empowered the board to make accurate risk level determinations, specifically saying that it's based on prior offenses. YO adjudication is a prior
And
offense.
168A repeatedly, when it defines sex offense, says a conviction, a conviction, a conviction, a conviction,
You're talking
equating.
about 168A.
A, right.
Yes.
Which equates conviction
Yes.
and offense.
Well, basically, that provision is, the definitional provision is basically saying what triggers the SORA provisions. A YO does not trigger SORA provisions. However, a YO adjudication can be considered. And the reason I say that, even though it says that in 168A, it's not, if you look at the statute, it doesn't, sorry, let me just get that provision. If you look at 168A 2C1, the way the statute is worded, it says, SORA applies if the offender has previously been convicted of a sex offense defined in this article. If the sex offense always literally means a conviction, this provision wouldn't make any sense, because what it would say is, the offender has previously been convicted of a conviction. It's just very circular. So if you read that provision, what it's basically saying is these enumerated convictions of these various offenses, most of which are sex offenses, is what initially triggers the SORA proceedings. So that's the way to read that. It doesn't limit offenses that would be able to be looked at. And the provision that under L does not say sex offense, it says offenses. So basically, it wouldn't cover that definitional statute anyway.
Provision under L doesn't limit it to criminal anything, right?
It says, L says prior offenses. It doesn't say criminal convictions, I believe.
You're looking at which part of L?
L5,
L5 says shall be based upon.
5, 3 little I.
Yeah, but 5 itself says based upon but not limited to the following.
Right.
So
And it
not
says-
limited to could mean anything that the board,
Well,
deems
but it
relevant.
expressly authorizes the board, it suggests that the board should be basing its guidelines on the number, date, and nature of a sex offender's prior offenses.
Let me ask you this. Could you use as evidence of nature of prior offenses, conduct that perhaps was reported to the police but never prosecuted for whatever reason? Let's say a husband and wife have a domestic incident, and there's a claim, this domestic incident report even filed of some sort of, whether it's a rape or whatever, but for whatever reason the wife chooses not to prosecute. Could you then, in a subsequent situation, use that conduct?
Well, there has to be clear and convincing evidence of it, so it would
Domestic
be
incident
less
report,
than,
she made the statement to the police, maybe it was even filed, but it never actually went forward to the point of a conviction because she, for whatever reason, chose not to cooperate with the
well,
people.
that scenario probably wouldn't, but if she'd made a sworn, if she testified in the grand jury, for example, and there'd been an indictment, and there was sworn testimony, that's
So-
possible. So it has to be clear and convincing. It doesn't have
So
to
the
be
offense doesn't
beyond
require a
Pardon?
conviction then?
an offense.
Nature of prior offenses then doesn't
to
require a
be-
conviction, is what you're saying?
It doesn't require conviction, but it requires more than what you have outlined.
Yeah, but that's, how do you have an offense unless you've been found guilty of the underlying
Well,
conduct?
It has to be, I mean, I would suggest that for youthful offender adjudications, there has been a conviction,
Well, I
which
think
is
that's the only way you get out of
basis
this, because otherwise it cannot be conduct that's not been found, right?
Well, that's
Even
not
under
our
Mingo,
case.
where's your reliability finding there?
It's not our case, so we don't have to
Understood.
decide that.
Thank you, counsel.
Thank you, Your Honor.
Ms. Yunus?
I just want to stress that, again, OYO is not a conviction. The statute specifically says that.
I'm having a hard time understanding your argument, where in the statute you derive your argument that, acts underlying a YO conviction can be considered for a departure, but not as a factor. It seems to me that that's sort of a convenient a way of making a distinction, but I just don't see where it comes from in the statute.
Because youthful crimes committed as, or conduct one engages in as a youth is not indicative of one's character in the same way, automatically assessing points conflicts with the legislature's intent, automatically allowing one to be a higher level than one would be without that. However, again, we're envisioning this in extremely rare circumstances where somebody might have, committed a very similar type of sex crime a few years earlier. We don't want to say that under no
So
circumstances.
there would have to actually be proof that in this particular case that was indicative? I mean, is it enough that, in fact, there was a second sex crime?
Well, that would be
Is
up
that
to the
the proof?
hearing court, and,
On what basis, though? But
well, that would be I'm not sure that I understand the question, I guess. On what basis?
can the court decide that you're saying it's not indicative. The experts have said it's not indicative, but there may be these very rare circumstances in which it is indicative. How does the court make that determination? Do you need expert testimony?
No, the way that it makes all other determinations. The court makes determinations about upward and downward departures, which are fact-specific and just depend on the arguments put forth by the parties. It would be no different than that. And
Your argument, I'm sorry, just to go to Judge Stein's point, is the abuse of discretion here was assigning a certain number of points for a YO offense.
yes.
Does it matter how many points they assign? Like, what if they assigned 5 for YO? Would that be an abuse of discretion?
Well, our logic doesn't change. No, there should never be an automatic assessment of points. Again, this upward departure could be reserved for very rare circumstances in which there was a clear pattern, and the court determined that there was a clear pattern that really was indicative of a risk of reoffense.
So, counsel, this whole argument turns on the body of science that you say supports this position, which is counter to what the board decided in 2006 or whenever it decided,
Yeah.
that the science was in the other direction.
Yeah.
Was that science-based argument, which isn't part of an evidentiary argument, squarely presented to the SORA hearing court?
The science was not itself used, but I don't think that changes the preservation analysis. The legal claim is the same. We're using a little bit more to support that legal claim on
Well, how
appeal.
is the legal claim the same?
The legal,
How is it that the hearing court really had an opportunity to consider whether or not the reason that the board exceeded its authority is because it based its decision, or it did not have proper basis upon which to come to this conclusion that you should get points for a YO?
well, the legal claim still rests on the statutory interpretation, which serves as the basis for our claim here. We're simply using science, which, the Supreme Court has recognized and other courts in recent years to buttress our argument. If I may, very quickly, youthful offender can be used at sentencing to enhance the sentence. It can't be used as a predicate, and I would argue that this is sort of a similar situation. The youthful offender adjudication shouldn't automatically enhance points in this way. The judge could look at it and say, again, this is a very rare circumstance in which an upward departure is warranted.
I'm sorry, where's the authorization to use a YO to enhance a sentence?
I believe that a YO, can be considered. It can't enhance the range, or it
okay.
can't change the range, but within the range, the judge can consider that in imposing a higher sentence than he might otherwise would have.
Thank
Again,
you,
we've
Counsel.
never
Thank you.
said that, that's just the appellate divisions.
Sorry?
It's just the appellate divisions who have said that, right?
Yes.
Thank you.
Thank you.